Hello and welcome everyone to the Analyst by Vajiram and Ravi. Today we are going to discuss 7 articles from the Hindu and the Indian Express. Now this we will take under 2 sections. First of all, analysis section, we will discuss in-depth 2 articles. First of these articles relates to judicial reforms. What is the current status? How over the years we have reformed them, and what is the need to further amend them? How can we do it? Second of these article relates to environmental governance. What is the concept? What we have been doing it, and how this issue relates to health issues and climate change also, and the way ahead for the same. In the second section, which is the simplified section, we'll give you 5 articles which will be helpful for your 2025 prelims. We'll also value add to all of these articles, so stay tuned. So coming to the first article of the day, which reads leaner, faster and fairer. This is in the context of judicial reforms. Recently, we saw that our CGI, the new CGI, entered his office. He got appointed as the new CGI. His name is Justice Sanjeev Khanna. So in this background, we have seen that judicial reforms have taken years, and we have successfully been able to reform some of the judicial processes and laws. However, still a large part of it and a large provisions needs to be amended so that justice remains accessible by the poor, marginalized, and even to the remote corners of the country. So let's see. First of all, we have to understand what are the components of judicial reforms. Why do we need it? So starting with, there are basic components of the judicial system or judicial reforms where we need to put our attention to. So it includes court system, it also includes investigative agencies, it also includes laws. Some part of it could be criminal justice system as well, and the various procedures involved. Second, we have to ensure whatever judicial reforms are there, they are effective, they are transparent, they are efficient as well. They do not lead to delays and the waste of time. And third, rule of law has to be followed. Not just the laws in word, but also the due process of law, so that the common public do not suffer. And the last, it has to be fair and timely. Like it has been said and re-emphasized by Supreme Court time and again, that justice delayed is justice denied. Hence, to give you one example, as you can see, this was regarding NJAC. What is NJAC? This is National Judicial Appointments Commission. So over the years, starting from 1987 till 2015, there were multiple efforts which were made to amend and probably to bring in the provision of NJAC into legal terms. However, over these series, as you can see, it started in 1987, where we proposed the concept of National Judicial Appointments Commission. It was recommended by Law Commission in its 121st report. Later on, it was introduced in 67th Constitutional Amendment Bill. However, the Lok Sabha dissolved in 1991 and bill couldn't be passed. Now, the similar things happened in 2003 and 2010. This time, again, one of the committees, an eminent jurist, M.N. Venkatacharya, recommended the initiative of FTR along with other judicial reforms. So yes, 16th session of Lok Sabha in 2013 tried that. However, this time, Raj Sabha did not pass it. Now, NJAC bill actually took form and introduced in Lok Sabha in 2014 again, which saw the success, and it was rightly passed by both of these houses. And in somewhere in 2015, NJAC Act was notified. So you can see, even to come up with one of the reform, it took long time and many years. And this is just one of the provisions which is a part of judicial reforms and this journey. So just get into more depth, and to understand this topic, you have to know first of all what is the critical requirement and need of these judicial reforms. So first of all, as you know, there are 3 basic organs of Government of India: judiciary, legislative and executive. Legislature prepares these laws and passes them. Executive is the one who implements it and executes it. However, judiciary ensures whether the laws passed are actually leading to the outcome of people benefit or public welfare or not, whether they are constitutional in nature or not, whether the due process of law is being followed or not. So hence the utmost important of the third organ of the government, which is judiciary. Hence the judicial reforms. Then you can see there is continuous evolution of society. Many norms have been changed pre-independence, also after post-independence. We have seen in many of the social criteria, right from rural to urban, to every aspect of life, you have seen the traditions and norms have been changed. What earlier was not acceptable has been becoming acceptable. For example, last year we saw the debate on same-sex marriage, which was few years was never heard of. Second, it is a dynamic and ongoing process. So, like I said, because of the various new challenges, which you can see in the form of challenges or new events taking place, that is, e-commerce have risen. Then there is emergence of social media also. Now, there are advantages to it, but yes, there are caveats and cautions, and also increased number of cases, because it gives multiple channels and outlets through which those cases could be formed. There are increased number of cyber crimes and frauds, online frauds taking place. Then new technologies like AI, cryptocurrency are all coming up. Now, this leads to an enhanced the criteria and multifold categories of processes and probably crimes that could be committed. So there is a need to adapt our judicial systems to include and elucidate all of these challenges so that we are able to disburse justice to the people who requires it the most. Then we have to ensure the basic criteria of equality, inclusiveness, and disbursing justice to all remains the core principle of any and every judicial reform. Now, there are multiple issues which plague Indian judicial system. We have amended it and we have seen successes as well. But there is a space which needs to be changed, and these amendments has to be there. So starting with, first of all, the shortages of judges. If you see and analyze the data given by the NCRB and National Judicial Data Grid, you would see that there is 35% of vacancy alone at the level of subordinate courts. Then India has 17 judges per million of population, which is not a very healthy and wholesome ratio. If you compare it with other countries, you will see that countries like France, USA, and Canada, and even Australia has better ratio. India has only 17 judges per million. That talks a lot about inadequacy, delays, pendency of these cases. Then there is the issue of appointment of judges. Collegium system few years back or still is grappling with issues such as non-transparency. It is oblique, and probably the appointment system is not as transparent and accountable as it could be. So there was a proposal to come up with a suggestion that includes advice of executive as well as the advice from Supreme Court or the courts in general. So that's why collegium system has issues, and that's why there comes up the issue of appointment of judges, and we do not see the adequate appointments. Then there are pendency of cases. Almost 4.5 crore cases are pending at subordinate courts. This is as per National Judicial Data Grid data. There is also infrastructure issue. If infrastructure is there, this is debilitating at that state, and if infrastructure is not there, that is because only 0.09% of GDP is devoted and allocated to this section. Then we have human resources, which we are at the side of inadequacy, be at the secretariat level or clerical assistants and public prosecutors. What happens is this also leads to delay. Why? Because some of the times these administrative tasks are generally handled and probably tackled by higher judiciary. So hence these some of the issues. Rest of the issues, let's take now. There is also lack of gender diversity. So far, no CGI has been any, there has been no women CGI so far in Indian context, and only 11 women judges in Supreme Court have been appointed so far. Then if we talk about under trials, as per NCRB data, we have already crossed 75% of the inmates, which are under trials in nature and which speaks volume about the state of judicial system in India. Then there are also procedural issues. Sometimes summons are not issued. Sometimes they are delayed by police and other officials. Then also some procedural laws. In the recently we saw that there were amendments, and which is a welcoming amendment. That Government of India came up with 3 of these amendments with replacing CRPC, IPC, and Indian Evidence Act. They came up with the names of Bharatiya Saksh Adhiniyam 2023. Bharatiya Nyaya Samhita and Bharatiya Nagarik Suraksha Samhita 2023. Now, but even then, after these amendments, we need that these have to be implemented well, and there has to be monitoring also. Otherwise, forming laws, forming codes never suffices and never leads to results if there is no proper execution. Next issue that we face is of extrajudicial work. Like I said, sometimes these legal services and extra administrative work is allocated to these higher judiciary and the courts, which already has a huge pendency and huge work pending. So there has to be this division of work which could be tackled at lower levels. Then, now that we have seen the issues, various issues plaguing Indian judicial system, we can talk about what does it lead to and how does it manifest. First of all, it leads in the administration of justice. Prolonged detention, the cause of prolonged detention, it is about, the degree of it is about 77.1% of over 5 lakh inmates are awaiting trial at this moment. Then there is also negative impact on justice quality. For example, if we are running through cases just to cover them up or just to fulfill them, sometimes there may be a case that the case in hand is not properly dealt with and the related issues are not catered to. Now, in that case, what happens is the same person, same plaintiff goes to the court again for addressing some part of it. So that again leads to a cycle and delay and wastage of time and resources. Then there are also financial burden on litigants. Some people coming from very marginalized communities or societies or who are socio-economically poor, they cannot afford the litigation cost. So we have to be conscious of these situations that we see on ground. Then there is negative impact on the economy as well, because if some, let's say some e-commerce or let's say some business venture is involved in a legal tussle, then it would lead to maybe loss of business or probably installment of that business and unresolved legal disputes. So that's why it is important that economy does not suffer, and in the end, judicial reform takes place timely, addressing each of these segments. Then there is also public generally loses faith in the judicial system if there are long delays, if there is lack of legal aid as well, because most of the common people are not aware and are not used to the parlance that is being used in courts, in these court galleries with this legal and bar terminologies. So it's very important that legal aid is provided to them, awareness is being spread, some IEC information and educational campaigns are carried out. So it is very important. So that is about the impact on the judicial system. Now, this is not to say that we have not taken reforms. Yes, like I said, we have taken multiple reforms over the years. Just to tell you some of them, starting with, we have undertaken National Mission for Justice Delivery and Legal Reforms. Then we have also undertaken development of infrastructure facilities for judiciary, and from 1993-94 up till 2022, you can see 9,013 crores have been spent. Then we have also worked on filling vacant position. 2014 to 2022, 46 judges have been appointed in Supreme Court and around 769 judges have been appointed in High Courts. Then there is recourse and alternate ways to adopt alternative dispute resolution. What are its multiple ways? First is Lok Adalat, then there are Gram Panchayats and online dispute resolution. These are out of the court settlement, sometimes not as formal as the courts, and also people are more used to going to these because they do not have to face all these facilities of formalities that have to be filled when you're going in a proper formal court. Then there are initiatives to fast-track special type of courts to cater to different needs, to different sections of the society, including senior citizens, women, children, and also the crimes, the heinous crimes especially, that needs early disposal of case and justice. Then there has been recently been amendment and provision of video conferencing to sort out these cases. To add to these reforms, there has been e-Seva Kendras which have been established and developed. This leads to e-filing services. It also addresses the cause of digital divide. Now, some of the people who are living in these rural remote areas, they first of all not aware of these terminologies. Sometimes they're also not aware to the recourses and the various solutions that are available to them. So first of all, if these kendras are disseminated, then this information could be given to them, and if they are aware, then they can take probably a recourse to this solution. Then we have National Judicial Data Grid, like I've mentioned multiple times. This gives you the judicial and legal data and the statistics required and information of cases and various orders and judgments. Then the next one, we also have National Service and Tracking of Electronic Processes. In terms of website, we also have Secure, Scalable and Sugamya website as a service, which is actually out in 13 languages, including English and Hindi. And it is Divyang friendly. So that increases the accessibility of justice. Then we have Virtual Justice Clock. We recently saw this example or probably provision being put on field in Gujarat High Court, where this comes up with vital statistics like case details. Then we have pendency, case disposed, etc. Also, we have a provision of legal services authorities, so which actually caters to socio-economic marginalized society, and which ensures that people are aware of the various provisions that are available to access justice. So these are some of the reforms that we have come up, and we have been successfully able to put it into our judicial system, but still there is a lot of gap. There are loopholes that we need to ensure that are plugged in long time, so that our judicial system remains and becomes holistic. So first of all, among all of these measures that needs to be taken is transparency in appointment. As per the Law Commission of India 2009, this has to be done with the collaboration and coordination of executive and judiciary. Maybe judiciary prominence, but with executive concurrence or probably consultation. Second is we have to reduce pendency. As per Law Commission of India 2009, maximum strength of judges could be increased. First of the one way of doing it or probably reducing pendency is to increase the number of judges. Second, you can also increase the retirement age of the Supreme Court and High Court judges at least by 3 years. Also, judge population ratio could be converted from the present 17 to 50 per million of population. Then we also have to ensure that optimum time utilization is there. This was also as per the Law Commission of India 2009, which recommended vacations of these higher court functionals and officiaries to be curtailed by 10 to 15 days, and the working hours at least to be enhanced by half an hour. Then we have to ensure that whatever new laws or new provisions are coming, they undergo the process of judicial impact assessment to have an outcome of how they are affecting the general public or the targeted population. Then we have ADR mechanism and plea bargaining. Of course, they are there. They are easier ways to get the justice and probably more acceptable as well. But what lacks is people's awareness and information about it. These lead to out-of-court settlements, which are easy, which save resources and times also. Then we have All India Judicial Services. We have to ensure that our government or probably national level judicial service is composed by the Government of India. This will recruit judicial offices across the country and also lead to uniformity for their appointment. Then we have National Judicial Infrastructure Authority. Like I said, seeing the grim status of 0.09% of GDP being allocated to this section, former CJI N.V. Ramana recommended the standardization of this authority and probably establishing it in the first place. So that is regarding the measures to be taken. Additional, apart from what I have just said, we can also simplify these procedural laws. Then we can also improve the functioning of fast-track courts. Establishing these courts is not enough. We have to get them with we have to avail them with the dedicated staff, competent staff, dedicated judges, and restructuring processes. So they are easier. And if anyway the process remains the same, which are usually being practiced in the court, then what is the purpose of establishing fast-track courts? So that's why the urgent need to simplify these processes. Then we have to set up an independent mechanism for legal services. It could be entrusted to the executive in consultation with high courts. Then you have to or probably we as a society or we as the government of India, we have to ensure that timely justice is given to under trials. As Supreme Court has reiterated, bail is the norm, whereas jail is an exception. Even in cases and even in law such as UAPA, Supreme Court has reiterated in the past. So then there is a case of representation of women, which former CJI N.V. Ramana said could be increased to 50%. There is a need to give or probably provide legal education where the provision of compulsory apprenticeship to the bar members has to be enrolled. Then research and training centers so that legislative drafting could be taught, or probably these bar members or probably these new advocates could go there and practice it and could conduct under these research and training center. They could conduct judicial impact assessment and they could train law officers. These are just few of the suggestions that we have to ensure while amending our judicial system. Now, having discussed this is your mains practice question of the day. Examine the potential impacts of the overwhelming case backlog and frequent adjournments on India's judicial system. Propose judicial reforms that can address these challenges and enhance the efficiency and transparency of the judicial system. Try to answer it into 50 words. Do write an answer for this question. Now, the second topic of the day, which is related to the concept of environmental governance. So, the context of it is that environmental governance has laws, but there is a need to probably establish this authority, which regulatory authority related to environment, taking in case the cause of climate change and health diseases as well. This has to be comprehensive, addressing every aspect of the humans and the populations living in this environment. So, first of all, what is environmental governance? First of all, we have to understand the basic of this. What does it include? Yes, it does include laws. It also includes institutions, organizations and various mechanisms that ensure that environment is in consonance with the economic development as well. So, there is an aspect of sustainability which is inherent in the concept of environmental governance. Now, the purpose is to manage all human activities, political, social and economic, and but the decision making has to involve the aspect of environment as well. So, this is regarding the environmental governance. Now, you will see, first of all, there has been evolution of this environmental governance in India right from the Stockholm Convention that took place. When it comes to Indian legal framework for environment protection, you can see that we have constitutional provisions, then we have certain acts as well, and there are sub-laws, sub-acts, and of course, there are certain institutions and mechanisms developed as well. First of all, to discuss few constitutional provisions, we have Article 21, right to life. We have an inherent and essential right to life, to live in a cleaner and dignified environment. Hence why role of Article 21. Supreme Court has also aligned with the same sentiment. Now, Article 48, which is also your directive principle of state policy. Hence, state has the duty to ensure the cleaner environment, protect and conserve the biodiversity as well and the wildlife. Then Article 51, which is the fundamental duty, and we as citizens are supposed to take care of the environment, not pollute it, and do whatever is in our bit. When 73rd Amendment took place, it also included certain aspects of environmental governance in the panchayats and local bodies. Then we have General Overarching Act, which is Environmental Protection Act 1986. One milestone that we saw taking place in 1985 was the establishment of Ministry of Environment and Forest, which in 2014 renamed as Ministry of Environment, Forest and Climate Change, keeping in the ongoing modifications and probably the requirement of the day. So this is one of the umbrella act that we have. It deals and it coordinates with all state parties. The center could coordinate with all of these state parties under all of these laws, which is Water Act, Air Act, Forest Conservation Act, Wildlife Protection Act 1972. Then there is Public Liability Insurance Act. We have others as well dealing with biodiversity, such as Biodiversity Act 2002 and Coastal Regulation Zone 2011. Then we see that in 2010, we also came up with one of the institutions and mechanism to put these laws on ground or probably into action. That was National Green Tribunal Act. Now, all the environmental cases and the cases dealing with the concept of environment or any of the issues there are probably heard by National Green Tribunal. So this is overall evolution of environmental governance in India. Now we see what is the current scenario and where our environmental status stands as of today. So first of all, in 2024, there was one report, Global Environment Performance Index, which actually placed India at 176 out of 180 countries. That tells a lot about the dire situation which India's environment suffer with. Also, second point is more than 300 coal thermal power plants still violate the emission standards. So the thing is, we have rules, regulations, and all of these mechanisms. But still, if the primary stakeholder keeps on violating despite established all of these norms, it's not going to it's not going to result in the outcome that we desire. Then, as you can see, these days we are getting news every day, probably smog from Delhi and the NCR region. This tells and speaks a lot about the situation that we have come down to. Then we have judiciary also has been ignored. Recently and from time and again, Supreme Court as well as the MOFCC, which is the Ministry of Environment, Forest and Climate Change, has come up with various directions. However, 2/3 of the states and union territories have not complied with those directions as well. So they just remain suggestive, they just remain advice, as mere advice and with no implementation. And that leads to recently, or probably one of the examples if I have to quote it, that led to illegal rat hole mining. The example would be of Meghalaya. Then we have other problems as well. There is poor coordination across government agencies, across states, interstates and interstates. There are no coordination with the agencies, institutions. Then we have institutional capacity, which is weak. We do not have staff, we do not have human resources, probably the infrastructure and the funds. Then we have lack of access to information. Proper data grid is missing in this case. Until we have exact statistics to what to do and what is the exact degree and gravity of the situation at hand, we will not be able to make any precise plan to deal with it. Then there is also stifled civic engagement. Either people are not aware, or if there are some provisions, they are not effective on ground. So these more or less gives you an idea about what is the current scenario as to the environmental problems. Let's see what are the challenges despite the framework, despite the evolution of environmental governance that India has seen. The weak implementation, like I've already mentioned, there is weak coordination, public awareness is missing. Emerging challenges, the recently challenges, the increasing health diseases, climate change, pollution, waste management, etc. have risen. And they are interconnected with the situation and aspect of environment. Data and monitoring is lacking. Like I said, critical statistics are missing. And the need to balance development and cooperation, basically economic development and environmental conservation. So the answer could be sustainable development. How? Let's see. This is the way ahead, which tells you what steps we can take, what measures we can adopt to ensure that proper and holistic and a comprehensive environmental governance is established and it is effective on ground also. So you have to integrate environmental with climate and health by probably one of the suggestions that author speaks about, by establishing environmental health regulatory agency. You can see some of the examples of this from this article also. It talks about establishing the same authority in US, in Germany, also in Japan, and they have seen successes as well. Then we have to strengthen the institutions, not just the central but states institutions also, and we have to ensure that they work in coordination and comply with the laws. Then effective implementation, for that we need to ensure that there is better monitoring. Increased penalties for non-compliance. Unless there are fines, unless there are penalties for non-compliant, people are not going to follow these. The same people are following it has been witnessed with certain case studies. When people are probably impose certain penalties, they tend to comply. So we can apply that principle and see what kind of success we are able to achieve. Then public participation, this is a crucial element, because unless the public sentiment and the public participation is not ensured, environmental decision making and laws would only remain on papers. Then, like I said, sustainable development has to be there. India, being a developing country, has its own issues and own requirement of economic growth. But it has to be balanced with environment protection, because India as a country, as people are going to live in the same environment, the people have to be healthy to ensure that economic growth also remains sustainable. Then we have green technologies, renewable energy in the form of solar, hydrogen, then wind. There are many ways that India is undertaking. And India has also come up with Panchamrit target, net zero by 2070. So those are very good and few of the initiatives in the environment perspective and reducing emissions that India has undertaken. However, we have to ensure that these technologies become affordable, because if the costs are higher, people will still resort to fossil fuels and the reasonable and the affordable technologies. So that's why probably by generating and producing them within the country, reducing the imports, probably working with the technology on the research and development aspect, we have to come up with the technologies which are affordable and scalable. That's regarding this article. Now, the question of the day. How has India's approach to environmental governance evolved since the Stockholm Conference in 1972? You have to mention current issues plaguing and highlight their impacts on sustainable development. Try to answer it within 250 words. Please answer this question. And now let's move on to the second section of the day. Now, coming to the simplified sections of the Analyst, very first article deals with the Bilateral Investment Treaty, that is BIT. So it reads the BIT model, the original model BIT that we have, and its comparison with India and UAE BIT. So a bilateral investment treaty with a bit of change. That is the heading of the article. Now, what does it say? It says that the BIT between India and UAE, United Arab Emirates, will replace the 2014 India-UAE Investment Treaty. It reveals India's latest investment treaty practice and might elucidate India's ongoing negotiations with United Kingdom and European Union. So these two organizations and probably countries, United Kingdom and this association, European Union, that we are discussing our BITs with, probably will be able to get some insights from the ongoing UAE and India BIT. Now, any BIT has two typical objectives. First of all, it has to balance the competing goals of investment protection and, of course, the state's sovereign right to regulate. Now, when I say state sovereign to regulate, it has its sovereign right to regulate, but not to abuse it. Second, investment protection also has to be there. So these are two competing goals as the first criteria. The second criteria is that it should contain unambiguous provision to reduce the discretion of the investor-state dispute settlement tribunals. So that is the second criteria. Now, in reference to India and UAE BIT, which actually departs from the model BIT that India few days back came up with, on some significant issues, we will highlight and take three major diversions from the model BIT. First of all, it provides that the foreign investor must exhaust local remedies for at least 3 years. This is a bit of change from the model BIT, which actually had 5 years. But however, there were grievances and many countries gave their opinion about, and they limited it 5 years was too long. So this is a welcome change. It seems that India has taken these concerns on board and softened its stance. Now, the function of investment treaties is to safeguard the foreign investment from sovereign regulatory abuse. So as long as India does not indulge in regulatory abuse, it has nothing to worry about. Now, second aspect from where India UAE BIT diverges from the model BIT is the definition of investment in this BIT, which states that for an enterprise to qualify as an investment, it has to fulfill key economic characteristics, which are commitment of capital, then profit expectation and risk assumption. However, the criteria that the investment should be significant for the development of the host state, which is present in the model BIT. So the investment has to be significant. This particular provision was a part of model BIT. They has been done away with, which is again another good development. Why? Because this term significant is subjective. It's general in term. It's very difficult to categorize it and to come up with exact definition of it. India and the UAE have reduced arbitral discretion by probably removing this provision. Then third provision which India and UAE BIT has as Article 4 of the India-UAE BIT, which talks about the treatment of investment, which lists when state action will amount to a treaty violation, and it specifically terms that when there is a denial of justice or when there is a fundamental breach of due process in dealing with investment. So it has defined treatment of investment very precisely, specifically. However, in the model BIT, the grounds are linked to customary international law, CIL. This term, however, is finding no mention in this new BIT, whereas in Article 4 of India-UAE BIT, like I said, there is no reference to CIL, which is again a positive development. The content of CIL, it contains various aspects of foreign investment, is not settled. A reference to CIL in the treaty, as numerous ISDS cases show, gives too much discretion to tribunals, and when there is too much discretion, there are emerging an increasing number of chances when these cases could reach to these tribunals and probably lie pending for years. Then there is aspect of continuity as well between both of these BIT, the model BIT and the India-UAE BIT. India-UAE BIT established a continuity of India's investment treaty practice. For instance, like the model, India-UAE BIT does not contain the provision of most favored nation and the provision, which is a core non-discrimination standard in any international economic relations. So state action on taxation is outside. The second aspect in the continuous section has been that the state action on taxation has been kept out of the ambit or the scope of the India-UAE BIT. Then, like the model BIT, Article 14.6 first of India-UAE BIT bars the jurisdiction of an ISDS tribunal to review the merits of a democratic court decision. Now, what do you mean by merits in this case? It means that ISDS tribunals should not act as a court of appeal. Otherwise, there is usually the procedure when there is one party loses the case in the domestic court, it usually takes to and resorts to appeal to ISDS tribunals. Again, that again leads to probably low confidence in investors and delay for years. And like I said, these merits can also have alternative interpretations and become subjective. Then on some issue, India also goes beyond the model. What so far model BIT has not talked about, this India-UAE goes ahead, a step ahead and talks about it. For example, it disallows third-party funding and unavailability of ISDS if there is an aspect or probably mention or an allegation of fraud or corruption comes up against the investor. So these provision you have to remember that it disallows third-party funding and also corruption and allegation of fraud if there, then recourse to ISDS is not possible. Then developed countries would be pleased with India's softening of 5-year domestic litigation requirement. However, they would still remain concerned about continued stance of excluding MFN and taxation issues from the BIT's ambit. So this was what this article read about. Now to add to the value addition with respect to the topic, what a new model probably for a BIT, what was the aim, why it came from, why we needed to change it. Then a government of India wanted to renew bilateral investment agreement with 47 nations. So India has been dragged because for years India has seen these cases ongoing in this ISDS tribunals and for international arbitration by many investors. So treaties will be updated in keeping with new economic situation. Many new cases have come up, many new situations have come up. Now, how this will be done? Now, treaties that complete 10 years will be allowed to relapse. There are certain countries with which we have these BIT signed. Now, when 10 years has been passed, we will probably relapse or the situation of relapse of treaty comes up and then we renew these treaties with renewed negotiations and clauses. These treaty negotiated as per the model treaty approach. So there is a need of model BIT that India or any country has to keep. Then it will be a template for all future treaties for all nations that we are discussing our BITs with. And Recently treaties, just in case there was some recently signed treaties, they will be updated later. How it will help? It will, foreign investors, first of all, will exhaust local judicial remedies before seeking arbitration. That will also, tax issues will be kept out of bilateral investment treaties. So this was some of the value addition with respect to the new model BIT, and in the actual article we discussed about the difference with the India-UAE BIT. Now to tell you and again highlight you in specific terms, BIT is nothing but an agreement, investment agreement between two countries to promote and to protect investment by each other's investors. What are the key provisions which are non-negotiable in nature? First of all, it has to be fair and equitable treatment. It has to dole out this fair and equitable treatment to all of the participants or all of the countries that it signs BIT with, and it has to ensure protection against expropriation, no seizure without due process and adequate compensation. Then free transfer of funds, profits, dividends and capital. Dispute resolution mechanism has to be an integral part of any BIT. Then what are the objectives? Of course, attract FDI, foreign direct investment, provide legal security to investor. First of all, to invite and to welcome any investor in different country, you have to give the facilitative environment, investment environment, so that they are welcome, they are confident to invest in that particular country. You have to also ensure, strengthen and ensure better economic relations between any two nations. So that's why this structural phenomena and the provision of BIT. Then of course there are benefits. It will encourage investment inflows. It will reduce risk for foreign investors. If they know that their money is safe and they know that it is progressive and probably mutually beneficial for both parties, of course they would invest in a country. It will also boost investor confidence. Now there are certain challenges as well. There are sovereignty issues. Sometimes country feels that the BIT investors are utilizing loopholes and are not ready to be regulated under the common country codes. Then there are investor-state dispute settlement, like we have discussed already. Then you have to balance invest promotion with public interest. Investment promotion cannot be without limits. It has to be qualified and has to be balanced with public interest at large. Now, the second topic of the day in the simplified section, which is about curbs imposed on annual temple jatra in Bandipur tiger reserves. So it reads that the Karnataka Forest Department has imposed restrictions on the annual jatra of Beladakuppe Sri Mahadeshwara Swami temple. So you have to read about this temple, and then which is in the core area, pay attention to this word, core area of Bandipur Tiger Reserve. This year event will take place from November 23 to 25. This is just to give you the context and the background. Now, core critical area of the tiger reserve. First of all, there are two segments of any tiger reserve, core area and the buffer area. So what we are talking is in the context of core critical area of this particular tiger reserve, which is Bandipur Tiger Reserve. What has happened is over the years, now this site resembles the site of any rural mela. That means what it indicates and justifies is that so much of things are happening which were actually prohibited in any core area. So that movement of man people inside the critical area continues, and this causes disturbance to the wildlife habitat. Now, to give you certain additions and helpful information from the perspective of value addition, this annual Jatra fair, Jatra is also known as fair. This happens in Beladakuppe Mahadeshwara temple in Karnataka. It's a significant cultural and religious event. There are some details about it, that this is in honor of Lord Mahadeshwar, who is a form of Lord Shiva. It is deeply rooted in local traditions and folklore. Again, celebrating the deity's role as a protector and benefactor. Time of celebration may vary as per the traditional Panchang, which is Hindu calendar, and it coincides more or less with Mahashivratri or other auspicious dates in the Hindu calendar. This was about, now I'll tell you about the location of Bandipur Tiger Reserve. This may be helpful for you from the mapping perspective, or probably the information about the core and buffer area of Tiger Reserve. So Bandipur Tiger Reserve, this, as you can see, this lighter green area, this is the core area that we are discussing. All right, and this dark green color, this signifies the buffer area. Any tiger reserve will have two sections of it. Core area especially has stricter guidelines as to the movement and activities being practiced in those regions. So this case highlights the urgency and also talks a lot about that even if despite multiple provisions and laws in place, it is not being effectively taking place. Then things about the location, Bandipur Tiger Reserve. It is situated in Chamarajanagar district, Karnataka. It is a part of Nilgiri Biosphere Reserve, which is UNESCO designated reserve, Biosphere Reserve, and it spans across Tamil Nadu, Kerala and Karnataka. It lies in Western Ghat, which itself is one of the biodiversity hotspot among 4 of the biodiversity hotspots that India has. Then about its history, as you can see, it was established as Venugopal Wildlife Park back in 1931 by the Maharaja of Mysore. Then it was declared a tiger reserve under Project Tiger in 1973. It is generally recognized for its efforts to conserve the Bengal tiger and its habitat. Now about the location of Bandipur Tiger Reserve and the nearby sanctuaries and Biosphere Reserve. You can see that this is the Bandipur National Park or Tiger Reserve. Then we have Wayanad Wildlife Sanctuary. We also have Mudumalai Wildlife Sanctuary. Nearby we also have Nagarhole National Park, apart from all of these that you can see in the graphics. And among rivers, Kabini, Nugu and Moyar rivers flow through or near the reserve. So remember all of this information. This may come handy in your prelims preparation. Now the third topic, rock cut footprints, human figure dating back to megalithic period has been unearthed at Kerala's Kanhirapoil. So let's see. If we talk about the syllabus of GS, this goes back to ancient history and probably art and architecture of the GS1. So as you can see, a remarkable archaeological discovery has come to light at Kanhirapoil in Madikai Gram Panchayat of Kerala, where 24 pairs of prehistoric footprints and a human figure have been found carved into rock on private property. Later on, this was handled by archaeological department and it dates back to the megalithic period. So yes, megalithic period, as a part of your preparation in GS1 subject, you have to know certain basics about it. Let's see what other things this article mentions. The carvings made with iron tools include footprints varying in size, and they vary from 6 to 10 inches, which suggest representations of both children and adults. At the end of the footprints, human figures has been intricately etched, accompanied by 4 circular pits around it. So there are 4 circular pits around it. Also, archaeologists said that the footprints represents, according to the folklore, that it represents souls of dead people and have been carved out to honor them. Now, one thing specific about these, that all of these footprints are pointing towards the west direction, and however, local people believe those footmarks to be that of goddesses. Now, these carvings bear similarities to prehistoric rock art found in Avalakki in Udupi district in Karnataka. So please know the locations of these districts. These were in news. You have to know the location as well. Then 2,000-year-old rock art sheds lights on the lives and artistic expressions of early inhabitants of Madikai Gram Panchayat and Kerala as a whole. These carvings and artifacts found here have long been attributed to the megalithic period. And of course, this goes back to prehistoric North Kerala. Now, some value addition with respect to this topic. First of all, certain points on megalithic culture, and it roots back to South India. There are various types of megaliths, as you can see in the image. There are menhir, there are dolmenoid cyst, topical, there are porehole cyst, then there are urn burials and stone alignment. So these could be in different forms for different purposes as well. If we talk about, to tell you or to give you certain examples, one of the types is large urns. They have a large pit and they are circulated, and probably there are demarcation of circular stone. This is the most commonly wide found, you must have seen in pictures. Then there are cyst. It has stone slabs, and a similar stone slab is put on the top. to cover it up. Then there is legged urn. It encased the body before actual burial. And the fourth one, chamber burial, cut out the compact using lateritic floor. These are few of the types. You can remember, this can help you in eliminating at least certain options. Second thing to know about these is arrangement of the burials. They have different and multiple types of arrangement. You would find at many places they are unique to that location, and it is used to mark the grave. Then there are megalithic burials with iron, and they have mainly been found in the Deccan part of South India. These are few images that give you an idea about these burials and the tools and the belongings that you will see along with the burials. Then megalithic culture and the times also saw a particular pottery which is also known as BRW, which is nothing but black and red pottery. This was the main pottery tradition of the Deccan Iron Age sites. Then also tools such as sickles, tripods, tridents, cross straps, lamps, multiple lamp hangers, etc. were seen in the form of iron tools from this age. Then you can see these are certain burial sites, megalithic burial sites. For example, Burzahum, Mehergarh, Chirand, Koldiba, Brahmagiri. Then you have, these are megalithic sites and some of the early village sites. You can see in the form of these small circles. So go through this map. This will help you in adding to your prelims based knowledge, and it will also give you some content to be written in mains answer. So moving towards the next article of the day, ICC issues arrest warrants for Netanyahu, former Israel defense chief, Hamas leader. So what is the background? Since the ongoing battle between the Gaza and Israel has been ongoing, so ICC, International Criminal Court, has issued warrants. So now let's discuss and read more. International Criminal Court issued arrest warrants for Israeli PM and of course Hamas leader Ibrahim al-Masri for alleged war crimes and crimes against humanity, where in Gaza conflict, for acts including murder, persecution, starvation as a weapon of war as part of a widespread and systematic against the civilian population of Gaza. It also included that there were reasonable grounds to believe that there is a blockade on Gaza and lack of food, electricity, fuel and medical supplies. This, what it did led to, it led to malnutrition, it led to dehydration and the killing and the deaths of civilians. The decision, of course, was met with outrage in Israel as well as from the Masri side as well. Hamas, although welcomed the decision, now Israel has rejected the jurisdiction, along with US also. Why? Because US in particular has not accepted to the International Criminal Court Convention, and Israel has rejected the jurisdiction of the Hague-based court. Again, the decision places Netanyahu in the same list as Vladimir Putin of Russia. Last year, ICC also included Vladimir Putin into the list where they would face the risk of arrest if they travel to one of the court's 124 countries which have signed and accepted the jurisdiction of International Criminal Court. If any of these travel to one of these 124 countries, there is a risk of they getting arrested. Now these 124 countries include most of the European countries, although US is not a part of it. Give you certain additions from this topic. This ICC personally has been established by the Rome Statute. This was done in 1998 and the headquarters is situated in Netherlands. As you can see that it was adopted in 1998 and court began to work in 2003. There are 124 nations who have accepted its jurisdiction. However, there are notable exceptions that includes US, China, Russia and India also. There could be a question where they could ask whether India is a member or not. So please remember this. Then you have to know the clear differentiation between ICJ and ICC. ICJ is a structural part of United Nations, while ICC is not. So remember it. ICJ, International Court of Justice, was established in 1945, while ICC, Criminal Court, this was established in 2002. It is the highest court of the UN when we are talking about the ICJ. And its location is again The Hague, the Netherlands. And it has its jurisdiction on all UN member states, and it deals with legal disputes between states and on request for advisory opinions on legal questions. However, there are no appeals to it. Enforcement part, none relies on effective. It has no enforcement power and execution power. It has to depend on UN Security Council to uphold its judgment. Now, when we are coming to International Criminal Court and seeing that it is not a part of UN, yes, though it is established and headquartered in the Netherlands, then it deals with the individual countries who has signed the convention and agreement. It prosecutes individuals for more serious crimes as per the Rome Statute. Yes, it has a provision of appeals, and it again has no enforcement power. It relies on cooperation from member states, from 124 member states that it has. So this is the critical division and the differentiation between ICC and ICJ. Then ICC in particular deals with 4 atrocious crimes, which are genocide, then crimes against humanity, war crimes, and aggression. They are further subdivided into various types. Like, for example, genocide can include intent to destroy a national, ethnic, racial, or religious group. Crimes against humanity may include murder, rape, imprisonment, enforced disappearance, enslavement, torture, apartheid, and deportation. Then there are war crimes as well. That includes attacks against hospitals, historic monuments, or buildings dedicated to religion, culture, education, art, science, or charitable purposes. The last segment and the crimes that it deals with has aggression, which includes against the sovereignty, integrity, or independence of another state that jeopardizes, and enforcement anticipated in 2017. It was added in 2017 at the earliest. So this was regarding International Criminal Court. Now the last article of the day is Russia fired ICBM after being hit with US missiles. This was said by Ukraine. So what happened? Let's see. Ukraine said Russia fired what appeared to be an ICBM, intercontinental ballistic missile, at the city of Dnipro on Thursday. And this was fired from, basically ICBM would be the use of ICBM in this war it's the first use in a war of weapon designed to deliver long distance nuclear strike. And in the 33-month-old war, this is the first time that they have taken to usage of ICBM. Ukraine fired, now this was in response to the fire that Ukraine fired US and British missiles at targets inside Russia this week, despite warnings. So this was in result, and probably this what it was driven by the attacks by Ukraine in the first hand, and secondly Russia replied to it. So ICBMs are strategic weapons designed to deliver nuclear warheads. They can deliver nuclear warheads. They can also deliver conventional warheads, and are an important part of Russia's nuclear deterrent. Again, Ukraine said that the missile was fired from the Russian region of Astrakhan, over 700 kilometers from Dnipro in central eastern Ukraine. So you have to remember the location of this. Where does it locate? On the border between Ukraine and Russia. Also, the missile fired is RS-26 Rubis. So we have to know certain details about it as well, which is a solid fueled intercontinental ballistic missile with a range of over 5,000, to be exact 5,800 kilometers, according to this association, Arms Control Association. So let's see some value addition to this part also. As you can see, this is Russia. This is the Astrakhan region of Russia, and this portion which you're seeing here, this is where Ukraine is located. So from here, the missile was fired towards Ukraine. As you can see, this is Russia, this is Astrakhan. This is a part of Russia only. To give you some details and some insights into ICBM, that it was first deployed by United States in 1959. It can travel more than 5,500 kilometers. And due to their powerful nature, they are considered as strategic defensive weapon. They are powered by rockets initially, but then they follow an unpowered free-falling trajectory towards their targets. They can carry, like I said, either nuclear or conventional warheads. And in Indian case, Agni 5 is the longest and of the Agni series, an ICBM, intercontinental ballistic missile, with a range of over 5,000 kilometers. So Indian counterpart is Agni 5. Here you can again focus on the location of Ukraine, Russia, and this is the Astrakhan region of Russia. Now, what is RS-26 Rubez or RS-26 Rubez? This is the missile that ICBM missile that Russia fired. Of course, there are technical details to it. You can see that this could be launched either from a silo or a vehicle. Then it has its length, diameter of around 1.8 meters. What's more critical, or what you have to remember, is that it has a range of around 1900 kilometers to more than 5500 kilometers. Payload of around 800 kgs. Takeoff weight, okay, you can remember it, 3600 kgs. And of course, this important warhead. It could be nuclear, single warhead, or multiple independently target re-entry vehicle. So this was it. This was regarding the prelims specific articles that would benefit you in 2025 prelims. I hope this session was fruitful for you, and all the best. Thank you so much.